In this session, we will be discussing the role and cooperation of the judiciary in enforcing arbitral awards and settlement agreements resulting from mediation. As I announced, a material of the panel sessions is on the official websites of the Ministry of Justice and the JCAA. Mr. Takatori, the floor is yours.
Thank you very much. And no break, sorry for that. And then just another 50 minutes. And then the first topic should be the significance of the amendment of the Japanese Arbitration Act, which is already some referred to. And then prediction of such effect by signing and ratifying the single convention, which I believe very strongly supportive and should be good things. And then the latest amendment points of the Japan Arbitration Act, and then practical effect and significance and impact by Singapore Convention to secure cross-border enforceability of international mediation, and maybe kind of a fairness when you are negotiating with the foreign companies, where the Singapore Convention is already signed, something like that, and prediction of the future impact of the convention onto the possible practice of cross-border dispute resolution. So those kind of things, I'd like to invite the Professor Kakiuchi to comment first.
Thank you very much, Takatori Sensei. It's a great honor and a pleasure to be part of this great panel. So let me express my gratitude to the organizers, the Ministry of Justice and JCAA. Now, let me first give a brief overview of the recent amendments and then talk about their significance. First, amendments to the Japan Arbitration Act. Because they have been repeatedly mentioned today, I will be very brief. Its main feature is the adaptation to the 2006 Citra Model Law amendments. And beyond that, the amendments also include additional measures to enhance the expertise of courts and to reduce burden to use court proceedings. And as for the ratification of the Singapore Convention on Mediation, I think to understand the significance of the ratification, it will be helpful to tell you a little more about the specific context concerning the issue in Japan. That is, as I mentioned earlier in my keynote speech this morning, the controversy during the legislative process of the current ADR Act as to the enforceability of settlement agreements resulting from private ADR services. As I explained earlier, in Japan, the basic legal scheme for private mediation services is provided by the so-called ADR Act, enacted in 2004, which introduced a certification system for private mediation services. This certification, which is given by the Minister of Justice, brings certain legal effects to the use of a certified mediation service, including nullification of a prescription and suspension of court proceedings. However, before the latest amendment, no special mechanism for the enforcement of settlement resulting from private mediation has been provided for even for certified mediation services. And this was due to the controversy as to the issue during the legislative process of ADR Act. The main argument in favor of the enforceability was the need for enhancing the function of private ADR. But in the legislative process, the opposition prevailed. The main arguments for opposing opinions were that, number one, since most settlements are voluntarily fulfilled, there is no need for a special mechanism to facilitate enforcement. Number two, that compulsory execution is incompatible with the nature of mediation as an autonomous and voluntary dispute resolution. And number three, that there is a risk that such a mechanism could be abused to the detriment of weaker party. Thus, in order to ratify the convention, it was necessary for the legislator to overcome these objections. The main motivation for the ratification was, of course, the need for enhancing the function of private mediation, but even if such a need were to be recognized, there were still a number of issues for the legislator to consider. First, there was the question of whether the Singapore Convention was compatible with the certification system under the ADR Act, because on the one hand, the Convention does not require any certification or qualification of a mediator, which is fully understandable as far as international mediation is concerned. While concerning domestic cases, it is difficult to admit enforceability of settlement issuing from non-certified mediation service, since it would ruin the basic idea of the certification system. This question is also related to the issue of whether a distinction between international and domestic matters is preferable or practicable. And another issue concerning the scope of application of the new enforcement scheme was whether the limitation to B2B cases is preferable or feasible. And last but not least, there was the issue of whether Japan should adopt the opt-in system or opt-out system. The solutions given by the legislator to these issues are the following. First, a distinction was made between international and domestic mediation. As a result, similar but different mechanisms were made for them respectively by the Act implementing the Convention for International Mediation and by the amendments to the ADR Act for domestic mediation. Both are similar as far as the compulsory execution of a settlement becomes possible by obtaining an execution order from the court. Their main difference is that in the case of domestic mediation, this scheme applies only to settlement agreements resulting from a certified mediation service, whereas there is no such limitation concerning international mediation. In this way, the legislator has maintained consistency between the new system and the existing regulations under the current ADR Act. Second, in both cases, the new scheme applies only to commercial disputes from which consumer, labor, or family disputes are excluded. And third, the new scheme applies only when parties have agreed that it could be enforced through the mechanism. In other words, Japan adopted the opt-in system instead of opt-out one. These recent amendments concerning both arbitration and mediation have two main aspects. On the one hand, they can be understood as efforts to catch up with the newest international standards, which are embodied in the amended UNCITRAL model law or Singapore Convention. On the other hand, they represent a further step forward in efforts to promote private arbitration and mediation, which have been ongoing in Japan for more than 20 years. The underlying idea throughout both is to enhance cooperation of the courts to achieve more effective out-of-court dispute resolution. And through this reform, it is expected above all that the risks associated with the use of arbitration and mediation, such as the risk of the loss of property during the procedure or evidence, and the risk that the other party will not comply with the arbitral award or settlement agreement. So if not, these risks could be eliminated completely, it will be at least reduced considerably, it is expected by this reform. And this will contribute to increase competitiveness of arbitration and mediation in comparison with litigation on the one hand, and with negotiation without third-party assistance on the other hand. And furthermore, these reforms, I think, will increase the expertise of the court, which in the long term is expected to further increase the credibility and attractiveness of arbitration and mediation in Japan. So that's my comment.
Thank you very much, Professor Kakiuchi, and many some critical issues which we have been discussing for the federally we should adapt Singapore Convention, and including the certification of the mediators and opt-in options, something like that, and then also the collaboration with the judges side. And as Judge Asakura mentioned, we have a very nice platform from now on. And then in the future, maybe we can have a good mediators, even from the retired judges or something like that. So please think about it. And then, I'd like to invite the Lenson's comment on those very interesting and critical points like certification and opt-in options, something like that, please.
Thank you. Thank you, Sensei Kakuichi, for your informative talk on Japan's perspective on the Singapore Mediation Convention. It is interesting to hear the debate about compatibility with between convention and the local mediation system. In fact, if it comes to enforcement of settlement agreements arising from mediation, generally there's no problem in Singapore. First of all, the Singapore Mediation Convention applies only to international settlements. Domestic mediations are not covered by the convention. Singapore has enacted an act to give effect to the Singapore Mediation Convention in 2020. And Singapore recognizes, just as the convention does, that there might be certain areas that a national court would want to reserve to supervise for itself. And therefore, even when Singapore enacted its act to give effect to the convention, it applies the carve-out in the convention. And therefore, the convention will not apply to settlements relating, for example, to family disputes, to inheritance, or to employment law. So these may be areas of concern that remain within the supervision of the domestic courts under its own domestic system. Likewise, if there is any mediation that is done by the court, and I was asked this question just now, mediation by the court, and the mediation results in a settlement that can be enforced like a court judgment, then it would not fall within the Singapore Convention either. So generally, there's no problem because the convention as applied in the Singapore statute is to give effect to international settlements of commercial disputes. Thank you.
Lenson, so for any comments on those points? No? Okay. So then I'd like to have the viewpoint by the Japanese practitioners regarding the impact onto the Japan platform and Japanese corporations in terms of the contract negotiations, something like that. So they maybe should include practice to enforce foreign arbitration laws and the interim measures regarding the Arbitration Act amendment, and then the impact of the Singapore Convention in view of the users in Japan, and which points should users or counsels or lawyers take care of from the timing of the such, contracting, something like that. I'd like to have the kind of practical comments from the Yoko Sensei, please.
Thank you. And I'd like to start my part by introducing my favorite statistics, which is published by a court clerk of Tokyo District Court back in 2017. And that is about the number of cases related to arbitration. And most of those cases are related to enforcement or setting aside of arbitration award. And there are, according to that statistics, there were 144 cases in 10 years, and almost half of them were filed with Tokyo District Court. And in very few cases, enforcement was refused or the award was set aside, but the others were either enforced or parties settled or it was withdrawn. The application was withdrawn. And with regard to the length of the time necessary for such procedure, of course, it varies heavily depending on the case, but about 70 to 80%, the case was done within an year. So from these statistics, I think it can be said that Japanese court is generally pro-arbitration. But the issue is that because there are not so many cases, there is a concern about the foreseeability on, in what kind of cases the arbitration award may be set aside or refused to be enforced. And also similarly, because there have been not so many cases, there are not so many court judges who are experienced in arbitration. So from that perspective, I think the recent amendment to the Arbitration Act to allow accumulating the arbitration-related cases to Tokyo District Court or Osaka District Court is very meaningful. And with regard to the translation, I also think this is a big one step forward because the cost of translation of arbitration award can be huge. And I filed an application for enforcement of the award last year, and it cost several millions of Japanese yen. And the award was, I forgot, but probably 200 or 300 pages. And such translation cost is not recoverable from the other party in general. And also, in many cases, it often happens that just after filing such application for enforcement or setting aside enforcement, the other party just voluntarily pays or both parties settle. So, and it is actually what happened in my case as well. So the cost of translation of the award can be such a waste of money. So allowing, omitting the translation of the award is, I think, is also a very huge benefit of the users. And with regard to the impact of Singapore Convention, as I already said, I'm a supporter of mediation, so I try to persuade the parties to try mediation whenever possible. But in my experience, I have not been very well done. And parties, especially actually Japanese parties, refuse to go to mediation before going to the litigation or mediation. Mediation or litigation or arbitration. And it is interesting, I think, because Japanese parties are generally well known, to to be in favor of the amicable settlement of the cases. So I asked my clients or the other party, why you do not agree to go to mediation? And of course, there have various reasons, but for example, they have no trust in the opponent. And because they have tried so hard to settle the case amicably, once such effort fails, they no longer have any trust in the other side, and they consider mediation cannot be successful. That is one kind of very common reason. And another reason that is frequently given, and what I think is interesting, is that they say mediation costs too much, or mediation takes too much time. And I think that might come from the history of, court-assisted mediation, or the the administrative type ADR or mediation. I'm not saying they are wrong, they are bad or good or bad, but they are just different, and they are like like smaller version of court litigation, I think, because there are several hearing dates and parties have opportunity actually to exchange, position papers or briefs for several times. So it is totally different from, international mediation, private mediation that we are talking about today. So anyway, so because of such, those are the kind of frequent reasons that I am given as a ground to refuse mediation. So when it comes to a question whether Singapore Convention could solve such, kind of distrust in each other or distrust in mediation system itself, of course, I think Singapore Convention cannot get rid of everything, but I think it can solve some part of the parties' concern, especially when it comes to the distrust in mediation. And I think as a side effect, there is also a side effect of signing of the Singapore Convention, because as I just said, one of the reasons for the parties to refuse mediation, especially when it comes to Japanese parties, I think it comes from some confusion between the traditional or mediation and international mediation. So, for example, because the Singapore Convention is going to be signed seminar or various information is becoming more available for the users about how the international mediation is conducted. So I think that is also a good outcome of Singapore Convention. And when it comes to the last point, that which point users should keep in mind, from the timing of the contract. The first point that I would like to mention is that, as already explained by Professor Kakiuchi, because Japan takes an opt-in approach, the opt-in approach means that the parties must agree that the mediation agreement is enforceable through the Singapore Convention. So it could be an idea that parties put in the contract that any mediation agreements that it reached between the parties is enforceable through the Singapore Convention. And I'm not familiar with, actually, I have to confess that I'm not familiar whether such agreement in advance can serve as an agreement to opt in, but at least I think it is better than having nothing. And the second point is that, as I said, sometimes the parties refuse to go to mediation, even though I think it's a very useful procedure. So it is kind of one thing that parties could consider is to have a tiered dispute resolution clause in the contract, which means that stipulates that parties have to go to mediation first before going to arbitration or litigation. So in such case, there is much more chance for parties to go to mediation.
Thank you very much, Yoko Sensei. Although I'm the moderator, but I have some comments on this viewpoint of the users. So the first thing is I agree with you. The trust is the kind of a key. But according to my experience, even in a case the parties are fighting and disputing very strictly and severely, but there could be a kind of chance to agree upon the reasonable dispute resolution process, like mediation, especially for the case in which the parties have been in a good, the long-time business relationship or something like that, and even if their trust on the substance issues is a kind of collapse, but then could be a chance for agreeing upon how to resolve the issues. That's my first comment. And then secondly, from the contract side, the contracting timing, you can think about the mid-up, rather than up-mid. And then some practitioners and arbitrators are saying that could be just wasting time. And then, why don't you guys go to the arbitration first? But still, I'm always saying to the clients that the trying mediation should not be regarded as just wasting time or a redundancy, because through those processes you can think about your legal issues and organizing the issues, and then trying to pick up the common interest or something. That may not be wasting time, even for stepping into the arbitration or real fighting. That's my just comments as the practitioner side. So then we'd like to hear from the Singapore Convention's leaders from the lesson and the possible practice and the practical explanation, including the distinction from SACC, because as we mentioned, we recognize the Singapore is very going ahead, and also Len-san is actually the teacher of the law school who taught even the minister Edwin Tan. Also, he's a kind of big leader of the arbitration and the mediation side. So I'd like to invite the Len-san's comment on those the situation in Singapore.
Thank you, Sensei Nakatori. Before I start, I just want to pick up your point about the multi-tier clause. Just be very careful, because there are many clauses very popular, especially in Asia, but even in Europe and the US, where they provide that you shall negotiate first before you go for mediation, and then if you fail, you go for arbitration. Now, controversies have arisen as to whether you can go for arbitration if you have not exhausted exactly the steps that are stipulated. In Singapore, the courts have treated it as a matter of jurisdiction. If you don't satisfy that, the arbitrator has no jurisdiction. And if the arbitrator has no jurisdiction, if he finds otherwise, you can go to court to challenge his jurisdiction. in UK and Hong Kong, they have decided that this is a matter of admissibility of the claim. The arbitrator can decide, and then it's not a matter that goes to jurisdiction, so you don't have the court reviewing the decision of the arbitrator. But it will still give rise to controversy, which is why the ARB-MED-ARB protocol is better, because you can just commence arbitration, and then you can go for mediation, take your time with it. Okay. I talk now about the SIAC, Singapore International Commercial Court, and how its role supports arbitration. The Singapore International Commercial Court is a division of the High Court of Singapore, so it's part of the court system. It was set up in 2015. I was actually a member of the working group that recommended it. And the idea was to provide international disputants, where you have international disputes, with a kind of a hybrid court system that takes good ideas from arbitration, so that you can cater to a more international group of users. So what is different about the SICC? First of all, it has an international panel of judges. It comprises Singapore judges as well as an international panel of very distinguished judges, including one from Japan in the first panel. Then you also can make submission as a foreign counsel on foreign law. You do not have to come before the court just to give evidence as an expert witness on foreign law. You can go to Singapore and just make submissions on the foreign law with permission. And parties also have the freedom to adapt a more flexible set of rules on evidence. So you're not bound by the strict rules of court. You can agree, for example, to use the IBA rules on the taking of evidence in commercial arbitration. The SICC is empowered or given jurisdiction to hear disputes arising from arbitration, such as challenges of awards, setting aside of awards, or enforcement of awards. And not too long ago, introduced a specialist list, which is technology, infrastructure, and construction, which gives more management powers to the court. And the court can also encourage parties to consider ADR. Now, moving that to the convention, the Singapore Convention, you have heard very good presentations on the convention. So I'll just touch on one thing regarding the convention. The convention, just like the New York Convention on Enforcement of Awards, provides that courts, contracting states must recognize settlement agreements and give them the effect of a judgment, except in certain circumstances, very specified, very stipulated circumstances. For example, if the settlement agreement is now void or one party is under some incapacity. But there are special grounds for refusing a settlement agreement effect, which are different from the New York Convention, and there are two that I want to mention today. One is if the settlement agreement is not clear or comprehensible. That means you didn't stipulate clearly enough what are the terms of settlement. And secondly, if the mediator has not complied with the standards expected of a mediator. So these two are new. And one big question then is, what do you consider the standards of a mediator? As we have heard, mediation is practiced differently in different countries. And one well-known case from Hong Kong, which is Gao Yan against Kin Ai, talks about how mediation was conducted in China against the expectation of the other party, because that so-called mediation actually sprung from arbitration. But the Hong Kong
no concept of the place of mediation, right?
Yes, there's no concept of the place of mediation. But in that case, what happened was the arbitrator, well, three-member tribunal, the Secretary General of the Commission, CN Arbitration Commission, arranged with a representative of one of the parties to meet one of the nominated arbitrators in private, have a feast to talk about the case. Then they went to the presiding arbitrator's house to talk about the case. And this is without the prior consent of the other. But then the award, when it came out, they didn't settle, went to an award, and it was challenged. The Hong Kong court says, well, it may look strange to you, but we have to recognize that mediation is practiced differently in different countries, and they upheld the award. So those are the points to look out for.
Thank you very much, Lenson. I recognize we missed the Nicholas comment on to the previous one, so maybe you can combine with the later one. But so very interesting points. So I'd like to invite the Professor Kakiuji's comment or questions to the Ren-san.
Yeah, thank you very much for telling us about the quite interesting situation in Singapore. Let me make 2 short comments. And my first comment is on the role or the nature of SICC, which is indeed a quite unique and interesting institution, I think. As you explained, many features of the SICC are borrowed from arbitration. So it looks like, as you said, a kind of hybrid of litigation and arbitration. And I wonder, as a legal scholar, from theoretical viewpoint, whether its essential nature is court or arbitration institution. When you say that many features of the SICC are borrowed from arbitration, it sounds like that it is essentially court proceedings, but borrowing some arbitration elements. But maybe we can say in the opposite way as well, that it is a kind of arbitration borrowing the form or elements of court proceedings. So I think it's, this institution is so interesting in that it invites us to reconsider the meaning of the distinction between state court proceedings and arbitration. So that's so quite interesting and inviting for legal scholar. And my second comment concerns Singapore Convention. And I agree with you that parties need to be very careful in drafting settlements terms very clearly in order to avoid possible troubles in the course of enforcement. And in this regard, in Japan, sometimes concerns are expressed about whether the parties or their representatives have sufficient capacity to do so, to draft clearly enough the settlement clauses. And in my opinion, the support by the mediator or mediation institution will be very important in this regard. And maybe some special training will be needed to enhance their expertise. So I would be happy if you have any additional comments from a Singapore perspective on this point. Thank you.
Yes, please.
Keep it to 1 minute. Thank you for the very astute observations. The first point is the SICC is a court. So although it borrows ideas from arbitration, and you can, like you say, interestingly look at it from the other way, it is set up legally as a court. In fact, the Constitution of Singapore had to be amended to permit foreign judges to sit as judges in a Singapore court. What you get is a judgment, so it will be enforceable under reciprocal arrangements or the Hague Choice of Court Agreements Convention, not under the New York Convention. With regard to the other point about what is clear and comprehensible, yes, that's a very important point because it goes to all agreements. If your agreements are vague, they cannot be enforced. And bear in mind that if your arbitration award is vague, it cannot be easily enforced. So if your settlement agreement is vague, you can't go back to the parties to ask them to add more terms because they will never agree. What is important, if I put it in a nutshell, is be very clear who is to do what by when. If it's a monetary judgment, pay in what currency by when. If it is to do something, do what exactly by when, in what manner. And I have, as an arbitrator, refused actually to make an award based on the party settlement terms when they came to me and say, we have agreed on this, can you make an award on this? And I look at it and I say, I can't even tell what you're supposed to do. You have so many contingencies, and be very careful about contingencies. How are you going to resolve them? So I made them clarify them before I rendered the award.
So then such kind of disputes could be triggered, right? And then we need to go to the Nakameguro Business Court, right? So, okay, thank you very much. Then any reaction from the Kakiuchi-sensei? Thank you. Then I'd like to invite the Nicolas' comment onto the previous Yoko Sensei's kind of viewpoint of the practitioners, and invite your comments on the recent discussion on the Singapore Convention in Hong Kong, including the Hong Kong mediators, arbitrators, and report on the future perspective, including enforcement of the settlement mediated, compared with the enforcement of the arbitration awards. So two things. Sorry about that. Could you please?
Thank you very much. I'll mix my comments on Yoko's presentation into my remarks. I can keep it very short when it comes to the Singapore Convention in Hong Kong. It's not enforced. So Hong Kong, the Singapore Convention has absolutely no effect so far in Hong Kong. It's always a bit tricky when it comes to international conventions and treaties and their application in Hong Kong. I'm sure you all know Hong Kong is part of China, but is a special administrative region with its own legal system and judiciary. So the application of international treaties and conventions in Hong Kong is a complex matter, which I will not go into today because the matter we're discussing is very straightforward. It doesn't apply in Hong Kong because China itself also has signed the convention but has not ratified it. So it also in mainland China, it is not in effect. It's, as I said, it's signed, but the ratification process is underway. I understand it might take a while because one of the issues that needs to be sorted out is so-called local issues that involves exactly how to deal with Hong Kong in this respect. So long story short, it's not in effect and it's in the foreseeable future not going to happen. Although you never know, it could happen tomorrow, but at the moment, at least, discussions are relatively quiet on it. So that makes that topic easy for me because it's not with a convention not enforced. I can't tell you the impacts of it on the Hong Kong practice. But what I will talk about is the points Yoko mentioned about general enforcement issues. I think enforcement obviously is always the client's favorite because that's how you get the money. In the end, we lawyers and arbitrators would love to talk about the procedures and so many arbitration topics which clients are never interested about because they want to know how do I get my money when I have my award or my settlement in this case. So when it comes to enforcing a settlement in Hong Kong, that is a simple contract. To be quite honest, it's you're enforcing a contract. It is not as such enforceable like a court or a arbitration award. So a pure settlement resulting from mediation doesn't really get you far in terms of enforcement. When you're mediating or settling during an ongoing arbitration, however, and this has been said before, you have several options. You can, again, only just record your settlement in a settlement agreement and be done with it. Then all you have is a contract again and tell the tribunal to terminate the proceedings. That can be done. Obviously, the much better thing to do is to ask the tribunal to record your settlement in an arbitral award, so-called award by consent or an agreed award. There's several terms for it. They're all the same. It's basically you're recording, you're putting your settlement into the form of a formal arbitral award, which is then enforceable like any other award in Hong Kong and in any other New York Convention countries. That, of course, is a very powerful tool to give your settlement an actual enforceable effect without the Singapore Convention issue in this respect. A quick remark from the arbitrator's perspective, because I sit mostly as arbitrator, and what you mentioned made me smile because I had a similar case where the parties came to me and said, "Oh, well, you're gonna like this. We settled." But their settlement agreement, it was not enforceable. I mean, they had made so many mistakes that I actually had to go back to them and tell them I could put this into an award, but you will have more problems than before. So that can actually be it's not always clear cut how you deal with it, and sometimes the parties need a bit of assistance. But I think that's also what the arbitrator is there for. You can't just assume that an arbitrator will put anything into an award and knowing it's not enforceable. So I think it's the duty of the arbitrator to make sure that an award he or she renders is actually enforceable, also if it is an award by consent. And now finally, the third scenario, an award following an ARB-MED-ARB procedure. And you have thankfully done everything I've written down here about the Gao case. I can spare you with that. You've heard the rather funny background of this very famous case in Hong Kong, the Gao Haiyang case from 2011. about this mediation in Xi'an in mainland China. I will add 2 points to it. Actually, the Court of First Instance refused to enforce the award that resulted from this arbitration, saying the mediation that was interjected in between the proceedings was biased, and as such, the following or concluding arbitration was infected by that, and its Hong Kong public policy was violated. So the award was not enforced in the Court of First Instance. It went up to the Court of Appeal, and the Court of Appeal, indeed, as you said, did enforce the award on 2 grounds. The one ground you mentioned already is that the court said you have to consider the habits and how a mediation is conducted at the place of arbitration. This was done in China, and in China, this was nothing out of the ordinary. What they've done, and this is an acceptable way of mediating, so it's not infected the arbitration. A very important second point, though, is that the losing party had not raised an objection against the how the mediation was conducted in the following arbitration proceedings, and I think that was actually the key reason that the Court of Appeal mentioned, that you can't dislike how this mediation has proceeded, then go back to arbitration, not say a word in the arbitration or not record a formal objection, and then in the enforcement proceedings of the resulting award say, oh, wait a minute, the mediation was tainted. So that was actually one of the key reasons that the Court of Appeal gave and said, well, you didn't object, you've waived your right, and now you can't bring it. And as a result, it was indeed enforced. So the takeaway, I guess, for Singapore Convention mediation, enforcing mediated settlements and ARB awards in Hong Kong is, for now, forget about the Singapore Convention. It's not in force. If you have a settlement, do record it in a consent award, because then you will get all the benefits, and also of the New York Convention. If you do not reach a settlement in an ARB proceedings and you feel like something was fishy in the mediation, raise the objection in the arbitration and make sure it's on record that there was a problem. So these are the takeaways, I guess.
Thank you, Nicholas. For contracting timing, especially for the dispute resolution clause, you have any advice to the Japanese corporations who are now doing the business in Hong Kong, or plan to invest in Hong Kong or something? You have any words for those Japanese corporations when what kind of dispute resolution clause they should draft or prepare? Some concern on those.
Well, at the moment, I think, as I said, the Singapore Convention, I think, is not an issue to consider at the moment. What is something to consider is certainly when you draft clauses with Chinese counterparts, is the interim measures arrangement that Hong Kong has introduced. I believe it was 2019. Whereby if your arbitration is seated in Hong Kong and administered by a certain number of institutions, that you can actually get, and this is the first time this is happening, support from the Chinese courts for your Hong Kong seated arbitrations. You can get interim measures from the Chinese courts, freezing assets of Chinese companies, preserving assets, etc. All the usual interim measures you would be used to in support of an arbitration seated in Hong Kong. So that is certainly, when your counterparty is Chinese, a huge advantage, because this so far hasn't been the case. And I'm sure it's a case that every lawyer in this room has seen, that it's sometimes a bit difficult running after the assets when after a 2-3 year arbitration, perhaps you have zero visibility of where the assets in China are going. And that's why that, I think, is a word of advice. If you can, and your seat of arbitration is in Hong Kong, look into the interim measures arrangement. There is a list of arbitral institutions that qualify under this arrangement, and they will actually then handle the entire process for you. You make an application with them, for instance, the JCAA, and they will then forward that application to the competent court in China. And these interim measures, preserving measures, will be in almost all cases are ordered, so that they have a very high success rate. So that's definitely something to consider.
Thank you very much for your information. Then, Yoko Sensei, any comments on to the Nicholas?
Yes, just wanted to comment briefly on the Gao Haiyan case. When I read an article on the decision of the first instance court of Hong Kong, I understand that that is not a kind of refusal of enforcement based on the reasonable concerns that we have for the arbitral procedure. And in that latter, the district court seems to refuse the enforcement or set aside, and because of some very exceptional circumstances that first, the parties didn't consent for the arbitral procedure, and second, I understand that even the party, none of the parties are present in the the so-called mediation, and instead, someone who has some association or someone had some influence over one of the parties or attended the mediation. So I think that is kind of extraordinary situation, and that even the first instance court in Hong Kong didn't disagree with the arbitral procedure itself in general. So that is my impression.
Yeah, I think that's absolutely right. It was a dinner at the Shangri-La, so they really had a good time, and this qualified that as a mediation afterwards.
Thank you. Any comments on this? No? Okay. So we have a few minutes left. Then maybe I'd like to have the kind of last word from each speaker, not only to the last question, but also for for overall. Yeah. So can I have the okay, Kakiuchi Sensei's comment first, for just a final word, including all issues for which we discussed.
Well, thank you very much for me. I learned very much about the situation in Singapore or in Hong Kong, and because we are now just beginning to entering into the world of Singapore Convention and the more effective international commercial dispute resolution, I think we need to continue to learn from other countries, other jurisdictions with more experience, and like SICC, new idea that we haven't had in Japan yet. So this was a very good occasion for me to start to consider about those questions. Thank you very much.
Thank you. So Yoko Sensei, please, any final word? No? Is it okay? So then Len-san, please.
Thank you. I think we should look now in this world that is developing on dispute resolution as a complete suite, and not look at each method in isolation. So litigation, mediation, arbitration, or any other forms. And I find it quite encouraging, because if you think back to a couple of decades ago, when parties deal with litigation, they have to deal with the peculiarities of litigation in every different court system, of which there is very little interaction and there's not much harmony. But with the increasing instruments on ADR, arbitration and mediation, we see now that the courts have also taken an international approach, and we are coming together with more uniform ideas on dispute resolution. It also makes things very interesting for lawyers in this field, that we can actually go to different countries and have this learning experience. That's what I want to say.
Thank you, Len-san. So Nicholas, please.
Maybe just a very general remark. As I said at the outset, I'm a civil lawyer practicing in Asia, where a lot of civil law and common law influences come together. And I think it's a fascinating time, as you said, when you think about a couple of years ago, that this was a very strictly divided world into, you had your common law countries, your civil law countries, the courts here and there, and basically they spoke a different language. And now we, through this whole suite of dispute resolution mechanisms that we've discussed, I think the world, in this respect at least, has come closer together and has developed, be it the IBA rules and taking of evidence, be it Singapore Convention, the New York Convention, like these international mechanisms and understandings of how to resolve disputes on an international scale, where, let's say, parties from wherever they come from could feel at home. So I think international arbitration in particular has come a long way in this respect. And I think the civil law world has learned a lot from the common law world, but I think also the common law world has taken a lot of the good things of the civil law world and brought this all together. And if you look at panels like this or other arbitration conferences where you have this very international crowd being able to come together and talk about the same topics on one level. And I think that's an exciting time to be here in Japan now as well, with all these new developments. And I'm very excited to see the JCAA flourish as well and come up as an important center in this part of the world. So I think it's a good time to be here, and I also congratulate the JCAA and the ministry on what they've achieved and where they've come from and where we are today. I think is remarkable.
Thank you very much, Nicholas. That's a very perfect as the final word from the this panel. So again, thank you very much for the this session with the very distinguished panel, Miyoko Sensei, Kakiuchi Sensei, and Ren-sen and Nicholas. Thank you very much for the audience, including the online audience. So I would like to conclude this session. Thank you very much, and then please join me to applaud to the those speakers. Thank you.
Thank you, Mr. Takatori. And thanks to all distinguished panelists for the excellent discussion. Please give again a big round of applause to Mr. Takatori and all distinguished keynote speakers and panelists today.